All right, I will now call the Committee on Judiciary to order. If the Secretary would please take the roll. Here, thank you so much. We do have a quorum. Please mark Senator Flores present when he gets here. Please mark Senator Orenshaw excused today. And we are just about ready to get started with this meeting of the Senate Judiciary Committee. We have two bills on our schedule today. We will take them in the order they're listed on the agenda, starting with SB 4. I know this is our first bill hearing of the session, so I'm very excited, and I hope you all are too. As a reminder, we'll invite the presenters down to present the bill, and then the members of the committee will have a chance to ask questions of the presenters. When we've concluded with the questions, we will move into testimony in support, then opposition, and then neutral. In this committee, we do not have technical rules about what allows you to be in support or opposition. I trust that you are all adults and you guys can tell us whether you would rather we do vote for the bill or don't vote for the bill. If you truly do not care whether we vote for the bill, but you just have some information you think would be helpful to us, that would be the time to testify in the neutral position. I also want everybody to know that we will generally limit testimony to 2 minutes per person. When we have a lot of people in the queue, whether that is the physical queue here in the room or on the phone, we may also limit the testimony overall to a reasonable time period, 30 minutes, 45 minutes, depending on our schedule for the day. And I also wanted to let you know that whether you testify verbally or not, you are always welcome to submit your comments in writing. I encourage all of the members of the committee to read those comments. Personally, I read everything that is submitted to the committee, and we will include those in the record most of the time. I think that covers all of the housekeeping for today's hearings, and I think we're ready to get started with SB 4. I think we have Deputy Administrator Crumring here to present the bill to us, and come on down whenever you're ready. Go ahead and begin. These microphones may be a little different from microphones you've seen in other rooms. There's a white button that looks like someone literally dropped a button on the table, and if you press it, it lights up red, and red means that the mic is hot, so we can hear everything you're saying.
Okay. Hello, Madam Chair and members of the committee. My name is Betsy Crumrine. It's Betsey Crumrine. I'm the Deputy Administrator for the Division of Child and Family Services over child welfare for the state. And I'm here today to present testimony on SB 4. I'm here today to talk about this issue, to address an issue that has delayed adoptions in the foster care system for the Division's Rural Child Welfare Program. Several years ago, the Division began hiring caseworkers with related degrees as a way to fill high vacancy rates in rural areas. This practice aligned with urban counties who also have broadened the qualifications of staff who work in the field of child welfare. Existing law, NRS 127.053, requires 2 disinterested parties must witness a consent to adoption, and one of the witnesses must be a social worker. Having this requirement that is only a social worker that can witness a consent to adopt is proving to be a hardship for the division, given the number of small offices that we have in rural areas. Section 1 of the bill proposes to amend NRS 127.053 to allow for a social worker or a caseworker employed by one of the authorized agencies under the law to witness a consent to adoption. Most states do not specify a specific job classification or title of who can consent. Terms used nationally include licensing child placing agency, a child welfare agency, adoption provider, to broaden the staff qualified to perform this function. For Nevada, the division is requesting to extend to caseworkers, and we didn't expand to an agency or another agency term. We kept it narrow, as we believe that this is a function of a caseworker and or social worker. As noted in my opening comments, the consequences of not adopting SB4 are that adoptions may continue to be delayed, as we don't always have a social worker available in a rural office to witness the consent at the moment a parent is available and decides to consent. Having to schedule a consent and track down a parent to come in again to consent could delay permanency for a child by several months. This will also assist smaller offices where the agency must provide a witness that has not had any prior involvement in a case, which includes removal, emergency on-call, consultation, further limiting the witness pool in rural offices that have small staff ratios. We have a few offices that have four caseworkers. This proposed change to statute was discussed with Washoe and Clark County prior to the BDR submission. Both are in support as they understand the dilemma and need in the rural counties. That concludes my testimony, and I can take questions if you have them.
Thank you so much. Are there questions from any members of the committee? Senator Krasner.
Thank you, Chair. Hi, thank you for your presentation. It says certain caseworkers, authorizes certain caseworkers. Number one, like who would those certain caseworkers be? First question. And then the second one, this is just allowing them to be the second signature, correct? Those are my two questions. Thank you.
So caseworkers are, is anybody with a related degree. So for a number of years, we were only permitted to hire social workers, but we had a vacancy rate of about 40% across the board with caseworkers because there weren't enough social workers. So we broadened our scope and added a class spec to allow us to hire people with a related degree. And as a result, our caseworker vacancy rate is down to about 15%, which is very helpful. Currently, one of the witnesses has to be a social worker, and we want to add caseworker to the statute so that if we don't have a social worker present, one of our caseworkers with a related degree could serve as the witness. So there are two witnesses.
Who's the second witness, please? I'm sorry, please, Chair, I apologize.
It doesn't, I don't believe it specifies who the second witness has to be.
Okay, so two witnesses, one of them is going to be now the caseworker in lieu of a social worker if their social worker is not available.
Correct.
Thank you.
Senator Lang.
Okay, so my question really doesn't necessarily deal with the bill, but I don't know where I was somewhere recently where people were telling me the amount of time it takes to get an adoption is really long, and I'm just wondering if you could address that.
Betsy Crumrine for the record. There are a number of factors that play into, I think, timeliness to permanency for children, and it sort of varies where you are in the state. One of the barriers that we have in rural areas is not having enough attorneys available who can facilitate the termination of parental rights that is necessary. If a parent doesn't consent or relinquish, then we have to terminate, and that is a very cumbersome, lengthy process, and we have struggled over the last several years without enough attorneys who are able to perform that task.
So have you gotten people together and tried to figure out how to solve this problem? You know, it just really is difficult for me because I want to get these kids in homes that are healthy for them.
Betsy Crumrine, for the record, we've tried a lot of things. One of the things that was tried was filing a motion for termination of parental rights, and I can't really speak in depth about that, but that was supposed to be a way to maybe expedite the process. I'm not sure that was super successful. In some areas, the courts have ordered the district attorney or the children's attorney in the case to file the termination of parental rights petition, but they are also very busy and they have a hard time getting that done any quicker than the Attorney General's office does. For rural Nevada, the way the system is set up is different than in the urban counties. And so in rural Nevada, the district attorney represents the interests of the community in court, and the agency doesn't have legal representation until we get to the termination of parental rights. And then at that point, the termination for parental rights petition goes to the Attorney General's office, and they file the TPR, termination of parental rights petition, on behalf of the agency. But sometimes years have gone by and there can be cases of files, and so it takes a lot to get up to speed on a case and then to draft the petition and file it. So in response to there being a delay there, the courts have tried, appointing the child's attorney to do it or the district attorney to do it. Some courts even got a grant to try and hire contractors to do it, but the problem is that everyone is really busy, and these are huge tasks, you know what I mean, to get up to speed on a case that may be a year, 2, 3, 4 years old. It's very time consuming.
Thank you for that, and I really appreciate the hard work that everyone's doing. And we have a lot of attorneys on this committee, and maybe they have some ideas, because I just think this has to change. Thank you.
Thank you. I think Senator Ellison had a question too. Go ahead.
Could you pronounce your name again?
Yes, it's
I
Betsy Crumrine.
okay. Going off on me.
I think it's interrupting.
Yeah, it could be. One of the questions I do have is if they are waiting on another social worker or a DA or something to do this, in the meantime, the child or children are putting in foster care. Is that correct?
I'm sorry, can you repeat your question?
Okay, if a child is waiting to get adopted or whatever, and they're still waiting for them to get rid of the parental rights, but the children, if they're taken away because maybe of a bad home life or something, if they do, while they're waiting for somebody to move forward with this, the adoption, where do the children go? They go to...
Betsy Crumrine, for the record. Well, that's a good question, and it sort of depends on the case. Often for the Rural Child Welfare Agency, about 80% of our placements are with relatives and or fictive kin. So we have a very high rate of placing kids with family, and often those family members will end up either adopting or entering into a guardianship with those children. So often the children are in perhaps the permanent placement that they're going to remain in. It just takes longer than it should to finalize that placement. And for other kids, it is not ideal. It means that they are, in a temporary foster home situation before we can finalize, a more permanent place for them. some adoptive families are not interested in even entertaining adopting a child that isn't free for adoption, because they don't want to get their heart broken, right? They don't want to take a child that isn't free for adoption and become attached, and so it is a problem, and it does prolong permanency for children,
Okay.
unfortunately.
Follow-up, yeah. Could you give me an average of what the most age limit is? I mean, from like 2 to 5 or 5 to 10, or have you know, what seems to be the average most people that are moved into different homes or whatever?
Betsy Crumrine for the record. I'm not.
Well, if say
entirely-
I say somebody's going to, you know, forfeit their parental rights, is it like, is the average of the adoption to go out or whatever, are they the young kids or older kids? I know it's kind of rough and it's kind of hard to say, but it seemed like there's a group of children that do get adopted or moved out to foster care at different ages, and it seemed like the younger they are, and the more they get moved. Is that correct?
Betsy Crumrine for the record. I'm gonna try to answer your question, but if I don't, please ask it again. It does appear to be easier to facilitate adoptions for younger children. Those tend to go quicker than teenagers, right? Or kids that are 12 and up. It's often harder to find homes for those children. They often have more behaviors. They're harder to place. Harder maybe takes longer to integrate into a family system. So the younger children do seem to be easier to place than, I would say, probably 12, 14 and up.
That's good. Thank you.
All right. Any other questions? I'm not seeing any, so thank you so much for your presentation. We will move now to testimony. We'll start with testimony in support of SB4. Anybody wishing to give testimony in support in person in Las Vegas or Carson City is invited down to the witness table now. And we will start here in Carson City, where we have a couple folks in person. Please just turn on your microphone, give your name and its spelling before you begin, and then you have about 2 minutes.
Good afternoon, Chair Scheibel, members of the committee. For the record, Cadence Matievich, C-A-D-E-N-C-E-M-A-T-I-J-E-V-I-C-H, representing Washoe County. Here in support of SB4, we don't want to repeat anything that you heard from the division, but we do think that this would be of benefit. We have caseworkers that are very much involved with these kids, and we think that they are appropriate to give the attestation. Thank you.
Good afternoon, Chair Scheibel and members of the committee. Jeff Rogan, J-E-F-F-R-O-G-A-N, on behalf of Clark County. For the same reasons, Clark County is in support of this bill, and we appreciate the department for bringing it forward.
Thank you so much. I don't see anybody coming down to the table in Las Vegas, so we will go to the phones, please, for support testimony on SB4.
Thank you, Chair. The public lines are open and working, but there are no callers to provide support testimony at this time.
All right, then we'll go to opposition testimony. Anybody wishing to give opposition testimony in person is invited to do so now, but I don't see anybody coming to the table in either Las Vegas or Carson City, so we'll go to the phones for opposition testimony on SB4.
Thank you, Chair. The public lines are open and working. However, there are no callers to provide opposition testimony at this time.
Thank you. We will then move to neutral testimony on SB4, and if anybody wishes to give neutral testimony, now is the time to come forward. I don't see anybody coming to the table in Carson City or Las Vegas, so we'll go to the phones and see if anybody's joined us for neutral testimony on SB4.
The public lines are open and working. However, there are no callers to provide neutral testimony at this time.
All right, then that concludes our testimony, and that concludes our hearing on SB4. We very much appreciate you being here, and that concludes our hearing. We will move on to our hearing on SB 126, and I'll invite Senator Neal down to the witness table, and I believe you have Officer McIntosh with you. Not with you. Well, then we invite Senator Neal down to the witness table to present SB 126. Please go ahead whenever you're ready.
Hi. Good afternoon, Committee on Senate Judiciary. I'm Senator Dina Neal here to present SB 126. So why did I bring this bill? It's the second time that I've had this policy, slightly different, but I am still on the mission to try to figure out how to create some kind of pathway that I believe should be a fair distribution of what is someone's pension. So I'm seeking to have an evolution of the rule that is currently the time rule for division of benefits. How did this come about? I had a constituent that reached out to me in 2022, and when they realized that they were going to retire at the end of their police career, they went to PERS and then they were told, you actually have a quadro. And the quadro, which is a qualified domestic relation order, which allows a spouse to get benefit from the pension, they were told that they were going to have to do a payout from their pension to their ex-wife, who they were only married to for 5 years. So then I started to research this issue and look into the case law and calling different parties about, how did this come about? And then when I found the Gemma v. Gemma case, I liked it because it seemed to represent the fact pattern. Let me be clear. The fact pattern seemed to represent the exact injustice that I felt was occurring, that occurred in 1989, that I was being asked to address in 2022. So in that case, basically, there was an argument that, and it was the same argument that my constituent was making, was that I was only married for 5 years. Now my retirement is going to be divided from the top 3 years of my earning. I haven't been with her for 20 years. So why does she get to take from 15 years 20 years that I wasn't even in a relationship with her? And how can this rule actually exist? And so I was like, and so when I started to look into it, I was just like, yeah, that doesn't make sense, because what should be happening in my mind, what is fair, is that when you divorce, that is when the benefit should be defined, and that is what the person should get. They shouldn't be able to get the top 3 years of their pension. So, i.e., I have SB 126. So in SB 126, I considered 3 things. 1, parties being educated on what a quadro was. I got introduced to a quadro in a very weird way, but it wasn't through a constituent. But most people have no idea what a quadro is. You can have it in a divorce decree, and you're like, I have no idea what this is, mainly because when you go through a divorce, almost all the people that I know have gone through a divorce, I don't think they're in a clear mind state. I also think that they're just signing to just get away from folks, and so they're not really clear on how this impacts their future retirement. 2, I wanted to actually apply the frozen benefit rule, which was adopted by the military in 2017. And the military saw it fit to actually do the freezing of the benefit for the amount of time that folks were married. So then I started to ask the question, when does community property stop accruing between 2 parties? And when I researched it, the statute or case law said that community property stops accruing upon divorce. So if it stops accruing at the point of divorce, then why is the benefit, the retirement benefit, continuing to accrue post-divorce and then being divided? 3, in the bill. I then wanted a very specific reference to the division of property in the actual divorce decree. Why? Because in the constituent who showed me their divorce decree, the way it was cited in their decree, they cited the case law. They said parties will divide per the time rule under Gemma v. Gemma. And when I read it, I was like, did you know what that meant? You know, I know you signed off, but the question is, did you know what that meant? So I feel like I'm trying to make sure that when a party goes in, they actually know what they're signing, so they know that futuristically what they're going to be impacted with. The other part, the other issue that I wanted to bring up just really quickly on why I brought 126 and then went back into, I guess, what I feel is a very controversial topic on who should get what, is because in my public policy viewpoint, I really do see the time rule as an unfair application, because a party is reaping the benefits of time, energy, and work that they did not participate in, and they were not a spouse. And the argument has been that because they were married and were a part of this relationship and they have a community property benefit, and because there's no way to just pull out the pension at the time of divorce, we should wait until year 25 and then divide the pension out. I understand that. However, I am of the different opinion that if I haven't been in a relationship with you for 20 years, and then at the end of that relationship, we have parted ways, and then you get to come back 20 years later and say, I get the top 3 years of your highest earnings, and when we were together, I made far less than that. I feel that that's unjust enrichment, and I don't feel that a spouse should be eligible to get that. I feel like they should get exactly what they earned in the marriage itself. So if it's 5 years, 7 years, 8 years, that's what you earned, that's what you should get. But that's not currently how the law works. The law works under the time rule, not the frozen benefit. This bill, SB 126, is seeking to freeze the benefit at the time that a person divorces, and then the benefit is then basically set at that point, and then the parties agree that they're only going to get 5 years worth of the pension, 7 years worth of the pension, or 8 years worth of the pension. But it won't be the math problem that I don't even want to get into the math problem, but there's a math problem associated with this calculation, which is the number of months that the person was married divided by the years of service. So I'll stop there, and then, because I know you guys have questions on the bill, but because we might as well just get into it. But I don't want to present any fractions, because even when I was in middle school and high school, well, it's not even middle school, elementary, I hated fractions. And so ultimately, I'm not going to bargain anybody down or with trying to figure out what the fraction looks like. But there is a case that actually spells out what that fraction is, and it's very clear. So with that, Madam Chair, I will open myself up for questions.
All right, thank you for presenting, and I think you're correct. You will have some questions. Who would like to go first? Senator Wynn.
Thank you, Senator Neal. I just have a couple of questions. First of all, it's giving me a little bit of PTSD from the limited amount of family law that I practiced. You had mentioned that the constituent that came to you with their divorce degree, had they had a lawyer at the time, or is this standard language that's in, I guess, some of the forms that you might be able to obtain from like a legal aid center or one of those kiosks?
No, they had an attorney. Senator Neal, for the record, they had an attorney. They were police officers. They can afford an attorney.
Do you know if, if that is standard language that people are, if they're doing their own pro se, like divorces or an uncontested divorce, if it's just in the standard language of all these divorces, or is it something that was put into place by, I guess, this person's attorney? Do you know?
So, Senator Neal, for the record, I don't know, and there's no way for me to just go and scale all divorce decrees that may have been entered, whether or not they were in some legal aid or 1-800 get your divorce or by an attorney.
Thank you. And then you had mentioned the frozen benefit rule from the military. Is there anything different about those military, I guess, because they have a similar but dissimilar system than PERS. Is there anything are you able to extrapolate that into a PERS type of situation as opposed to what the military pension is?
Thank you for that question, Senator Neal. I thought that when I looked it up, that the military actually had defined benefit, which is the same as PERS, which is a defined benefit, meaning that it's based on the years of service in which you are under the military system. Like in PERS, it's the years of service. So if you're officer, like you could retire at year 25, you can retire firefighter at year 20, and so it's based on the years of service in which you are designated to, legally bound to operate in order to pool your pension. So I thought it was similar. So if you know different, I have a, what is it called? It was the National Defense Authorization Act for fiscal year 2017.
I don't know specifically, so if there's anyone that's testifying in support or opposition, or they could answer that, I think that would be helpful. Chair, I just have one last question, if that's okay. I know that a lot of times people, when they're going through divorces, one of the biggest complaints they have is lawyers are just billing and billing and billing and billing. Sorry, lawyers in the audience. On these family law cases that are already contentious. People are already emotions are heightened. A lot of times there's kids involved and property, and obviously at some point they got married. Would there be a valuation at the end of the divorce? Like, would you have to pay for someone to value what that pension is worth or what that PERS is worth at the time of the divorce? And would that add, I don't know how that would take place. Is there do you have to get an auditor, or do you know how that takes place in other jurisdictions that may have this similar kind of system?
Thank you for the question. So when I was reading how the military does it, the division is done right at the time that the divorce decree happens before the judgment. And so the court will look at they're looking at what is the hypothetical retirement benefit that person was supposed to receive at the time of the divorce. And then they calculate it based on that. So, I'll just stop there.
Thank you, Chair.
All right, who else has questions? Senator Ellison?
Thank you, Madam Chair.
Mrs. Michael?
I got a lot of texts back on this bill, and I just got them, so I didn't have time to go through them all, but there's a lot of case law in here in opposition to this bill. And where Betty Jo just gave them to me, trying to go back through all these case laws, it'd take a while, but it seems like it's all in Section 2, SB 126, reason to a parent of frozen benefits, where it's freezing, and it also it goes back and it talks about times of marriage and stuff like this. So it looks like there's I'm going to have to go back and go through all these to see what the laws were, look them up in the laws, but I can't believe all these letters from the Supreme Court people or lawyers from out the state and in opposition.
So, Senator, I don't know if I should say, Senator Ellis, can you tell me which cases?
Which cases?
Mm-hmm.
Oh God, where do you want me to start? property alimony where the intention in inverted NRS 12511 is one of them. I oppose it to be 126, not eligible. I oppose 120, very similar to bill to SB 434, opposed it 2 years ago. Okay, what? Senate Bill 126, that runs afoul and NRS 125150.
Senator Ellis, can I address some of what you're saying? So SB 434 was the bill I had in 2023.
That's right, I figured that out.
It is different. Different because I had a little bit more in that bill and it's a little bit more explosive. Still had the frozen benefit rule, but in that bill, I was actually trying to figure out how to find an escape hatch to go back and to see if they could go back to court and challenge. So it's a very different bill, right? Not the same.
Okay.
The other, because I believe you're citing to NRS. And so when you talk about Nevada revised statute, right, the whole idea of bringing legislation is because you want to change the NRS, yes? And you're seeking to evolve the current statutes into a different concept, meaning moving away from the time rule to the frozen benefit rule. So it seems like some of those letters were citing to the NRS. I could see that some of them probably cited to, there were, I believe 3 Supreme Court cases. They kind of all build on each other. So the one I mentioned at the beginning, which was Gemma v. Gemma, and I don't know if you were reading off the numbers, but it was from the Supreme Court of Nevada, which was the case that I mentioned where Joseph Gemma was he sued because he was actually, he was in the fact pattern, he was upset that the ex-spouse was going to be able to take from the highest 3 years of his retirement. There was also another case, Certic v. Certic. That was another Supreme Court case, but I think you should distinguish the facts between the two because in the Certic case, the argument that was made was that in the fact pattern that the court made an error and that the court had used the actual salary versus the average of the 3 years. And so the party in this case challenged, and then the court then reverted back to Gemma v. Gemma to then say you should have applied the time rule and that you were mistaken to use the actual salary at that year, and you should have used the 3 years average. The other case, and I don't know if that, because I have no idea what's in your emails. I don't read the opposition, and I haven't had time, but I know they're here. I think the other case was Fondi v. Fondi, and I think what was interesting, this is the one that I mentioned where I think it's a good illustration case because it actually spells out the formula. It literally lays out and it reiterates Gemma v. Gemma again, which is the time rule that we've currently been under, and it spells out how this accrual of the formula is created, where you use the number of months in which you were married. So if you were 5 years, think about it like a car, and you're like, okay, it's 60 months, and then, so that's the top number. And then the bottom number, which is the denominator, is it could be 25 years of service. And then you do the division, and then you come up with a fraction of that benefit, and then that is accrued to the spouse upon the retirement. But it is taken from the top 3 years of their earnings in the pension system. And so I understand Supreme Court cases exist. They exist because the law is what they have to review on, right? So when you think about any Supreme Court, right, they say what the law is. And here's SB 126, who is seeking to change the law. All right.
Yeah, and I seen that, Gurma versus Gurma in the Supreme Court And then it comes back to Fondy, Mr. Fondy, in his 206 Nevada 856-802. The current, it goes back through the rules and regulations on so if I was married for 10 years to somebody and I owned, say, apartment complex prior, and you got divorced, would she be or he be eligible for have that apartment complex? It looks like to me the thing that comes into here the most is PERS.
Yeah, I'm only referencing the retirement benefit. I'm not getting into what is the acquired property before. I'm talking about how the retirement benefit is divided. And what I'm seeking is that it is frozen at the time of the divorce. So if you got divorced at year 10, your retirement benefit that you would get if you retired at age 75, I would freeze it at year 10 rather than at the age of 75, you having to then divide out that asset at age 75 and then do the math problem based on your 30 years of service, right? So I'm seeking when the relationship ends, that's when the retirement benefit, whatever the accrual is, that is what you should get. You shouldn't get an additional interest that is accrued over another 20 years that you are no longer in that relationship with that person. That at year 10, when the relationship is over, whatever that was the community benefit of that pension is 10 years. That's it. Not later on, 10, frozen, right there. End of story.
Yeah, I apologize, ma'am. This is an educational thing for me. In case I want to divorce you or something. You know, the other thing on PERS, but that takes in both incomes, if there was two incomes. Is that correct? So if I had a spouse that worked 8 years and I worked 20 years, and we were married 10, she could only take a portion of away from what her salary was. She gets to keep her salary, or he wife, you know what I'm trying to get at? So you've got to make this equal between both parties. Is that correct?
I'm going to use the word fair. So in your example, right, so if it's 10 years, this is going to be bad math. So let's say if there are 5 years and we know that there's 60 months, so then it would be 120 months. This is the current rule. So it'd be 120 months of your marriage, right? And then at the bottom, it would be your 30 years of your retirement. So that would be the bottom number. And then they would divide it, and then they would come up with a fraction of that, and then she would get, or he would get a payout from the year 30, not year 10 of the divorce, right? But that's currently the math problem. But what I'm seeking in 126 is that whatever that 120 months is the 120 months, and that is what we're going to use. So if you have 10 years of service, it's 10 years that you're going to accrue for that benefit. It's not going to be, well, because we had to wait 20 years to get it, we feel that the person has not reaped the benefit of what they gave into the marriage, because ultimately they're no longer in the relationship. You've been working, you're no longer with this person, and the way that the rule works now, they actually get to wait until you divorce, wait until you retire, and you're making more money, and then they take from that. And so the argument of the opposition, right, and this is the same opposition I had in 23, is that that is not fair. And I disagree, right? And that the whole point of having a hearing in a committee is to, open up the statutes to debate, right? You bring a bill, you don't necessarily, it's no kumbaya. You talk about it, and then you debate whether or not the policy is worthwhile changing or not.
Any other questions from members of the committee? So I just want to clarify one or two things about how divorces currently work and how they would work if we were to pass SB 126. And so, and it's about when these payments are made, because I want to make sure I'm understanding correctly. If I have a client today who has a PERS benefit and gets divorced from their spouse, that person today knows that in 20 years when they retire, assuming they're 20 years from retirement, in 20 years when they retire, they know that some portion of their retirement will have to be paid to their ex-spouse, but they don't know what that amount is.
Under the current time rule, they have an idea, because you know that you're under defined benefit, which means that you can only retire at year 25 or 20 unless there's some medical issue.
Okay, so then if the time were frozen though, if my client gets divorced tomorrow and they've been in the system for 5 years, we would be able to calculate at the time of divorce, between your 5 years, your 3 highest earnings were, let's say, 100, 110, 120,000, so we have an average of 110. We'd be able to calculate on the date of the divorce, okay, your retirement benefits are going to be $5,000 a month, therefore your soon-to-be ex-spouse will be entitled to $2,000 a month once you retire. Am I understanding that right?
Yes, because that's the way I understand it. So when it first rolled out, right, it was all complicated, but now we're, 8 years into the military frozen benefit. And the way that it works is that at the time of the decree, the judge has to put in what he believes would be that amount that the person would receive at the time of the divorce based on the years.
Okay, but the person who is the PERS beneficiary doesn't have to pay out their now ex-spouse at the time that they divorce. This is a future cost to them at the time that they retire.
Yes.
And that part doesn't change, because that's how it is right now, that you...
Well, it's different only because the math problem is different. That's the best way I can say that.
Okay.
The equation is different.
That makes sense to me. I think maybe let me ask my question from the other side then. If my client is the person who doesn't have PERS, either way, so they might be getting divorced today at age 40, and they're going to move on with their life, they're going to go do other things. Whether we utilize the current math equation or the SB 126 math equation, either way, they're waiting 25 years before they're actually getting this money. It's not like their ex-spouse writes them a check for the amount of their perceived value of their PERS benefits.
That is correct.
Okay.
Because they can't, typically the benefit is not anything that can just be withdrawn. So they're waiting. And I know that, the argument is that because you're waiting and you just can't receive it immediately, the person should reap the benefit of that interest or whatever.
And under both systems, would the parties be able to negotiate that? If, someone is lucky enough to be wealthy enough, could I suggest to my client, actually, if you just let her have the house, let her pay, let her sell the house and keep the equity, and then she won't get any of your PERS in 25 years?
Senator Neal, for the record, yeah, you can negotiate that, right? So you can negotiate alimony. The thing is that typically, right, most people, I would say some are, but then not, I'm leaning on the constituents that I serve. They're not negotiating that, or they don't understand, right? I mean, you throw out the word quadro, right? So let's say at the end of the day, the thing that I walked away with in this bill was you explain what a quadro is, and 2, you specifically define it in the divorce decree. Not only have you created a more educated group of divorcees who understand what that future impact is going to be, because most don't. Most are like, wait a minute, I've retired and now, what do you mean I have to pay my ex-spouse? Like, I haven't talked to this person in like 15 years, and now I have to pay this person a portion of my PERS for like the rest of their life. They're already remarried. They have their own benefit, and now you're saying that you're going to take the top 3 years that I earned. She or he have not been with me. They're not a part, the community asset has already been divided, but now you're saying that she gets to come back or he gets to come back and take. I think most regular citizens don't understand that. And I think most are in shock that they have to pay their ex. And I understand that there's some good attorneys out there, but not all attorneys are equal. And they're also not all following, best practices of how to explain to your client that you're really, really getting ready to get into a serious situation. And I'll just make this last caveat, because I had a constituent that got divorced it was in COVID. It was like 2021, and I have a very weird district, if you guys don't know, but a lot of people call me for a lot of random activity. And so they were in a divorce, and I started because I'd had the bill, and then I had been researching and thinking about this, and it was in 2022, and they had a quadro at the bottom, and I was like, well, that, because he didn't have a retirement. The wife did. She worked for the health district. And I said, I'm not necessarily a friend of your wife. I'm not trying to offer anything, but you might want to have a conversation about what this means. Because basically, you're going to take from her retirement. And I know that based on how this relationship is going right now, she might kill you. So, because it's a very contentious divorce. And I was just like, you might need to work this out. And I'm just going to put it right there. And then they went back and looked at it and had to ask their attorney, like, what does this mean? And ultimately, whether or not this is something they would agree to.
Okay, thank you. Any other questions? I don't see any questions, so thank you so much for your presentation. We are going to start with testimony in support of SB 126. Anybody wishing to give support testimony in person is invited to the witness table here in Carson City or down in Las Vegas. And in case you missed it earlier, we have new buttons. They look like stickers on the table, but if you touch them, they light up. And when they're red, they're hot. So your mic is on. Please go ahead whenever you're ready.
Go ahead, buddy. Okay. Good afternoon, Chair Scheibel, members of the committee. My name is John Abel, John-Abel. I represent the LVPPA and Public Safety Alliance of Nevada, representing the vast majority of law enforcement in Nevada, and we wholeheartedly support this bill. Thank you so much.
Good afternoon, Committee. Todd Inglesby, President of Professional Firefighters Nevada. We support this bill. I think the Senator did a great job explaining it. I have been through the process. I had 3 attorneys in that process to finally get it correct. Then had to get a quadro attorney to handle the quadro. So it is very complicated. I also have several members who have been divorced for 10, 15, 20 years, go to retire, and because the attorney they used at the time didn't get a quadro because the quadro was retired, that they were now going back to court to negotiate a quadro with someone that they hadn't been with for over 20 years. Last year, I think the bill did come up. I'm not sure exactly what the answer is. I think it should be fair and reasonable on all sides. Speaking to myself, I was married for 10 years, divorced. I'm going to still continue my career for 20 plus years. But now each promotion that I go up the ladder for, my promotion is going to my ex-spouse, not to my new spouse, not to my kids who, if something happens to me, a portion of that goes to my ex-spouse. The other thing I think is important to note that I have to, during that decree, decide and pay my deferred comp that I pay into. I also have to pay all the contributions. PERS is a big issue this year. I'm paying all the increases to those PERS for all the years that I'm not with my ex-spouse, but my ex-spouse benefits from those too as well. I'm happy to answer any questions. I'm no expert, but I can definitely walk through and understand why this is important. Also, the other thing, like I said last year, it became more of a men and versus woman or whatever. There's more women in PERS than there is men through if you combine the PERS system. Thank you. I'll be happy to answer any questions.
Since you offered, it looks like Senator Ellison has a question. Go ahead briefly.
Hypothetical question. How long were you married?
10 years.
So out of 10 years, you got divorced.
Yes, sir.
And the divorce was final.
Yes, sir.
And then 10 years later, she comes back and wants more?
My second attorney.
If you can put your name on the record, please.
Todd Inglesby. My second attorney told me about the necessary quadro, so then I had that put in during my second trial over that we were dealing with. So it took me two attorneys to get the quadro in there. And then I had to pay the quadro attorney because there's a quadro attorney versus attorneys who can't handle quadros.
Thank you, Madam Chairman.
Absolutely. All right, I don't see any other questions. Thank you for testifying and for answering questions for us. I don't see anybody coming to the table in Las Vegas in support, so let's go to the phones for testimony in support of SB 126.
Thank you, Chair. The public lines are open and working. However, there are no callers to provide support testimony at this time.
All right, in that case, we are going to move to opposition testimony. I understand that we do have a number of folks in opposition. We have received several letters, and I would like to include those in the official record. So if you submitted a letter, that will be included in our record. And I spoke to some of the parties earlier. I think we have a couple of attorneys here to testify who are also willing to answer questions in opposition, so I'm going to ask them to come down first. And if you can limit your initial comments to approximately 2 minutes, and then I'll open it up for questions to the panel, to the committee. And then we'll go into the rest of the opposition testimony if there are other folks here to testify in opposition. But starting with our attorneys here, please go ahead whenever you're ready.
Madam Chair, members of the committee, my name is Melissa Exline, and I am a family law attorney practicing in the north of our state. And I am here to testify in opposition of SB 126. I'm happy to answer some questions, but I did want to make a few main points that I hope to clarify from some of the testimony that was provided today. And I do have much respect for Senator Neal, and I do think her heart is in the right place, so I think that's an important point. But if the PERS share of the pie is smaller, if you shrink that pie down, what SB 126 is asking us to do is to pretend like the PERS spouse is getting retired on the date of the divorce, okay? So when you look at the entirety of a pension, the reality is each year builds upon the prior year. And unlike other assets, they inflate at the end. And so you don't get to those high 3 years without the original 15th year and the 10th year and the 5th year. And so what was looked at in the cases that were cited in Gemma, Fondy, and Sertic that Senator Neal made a point of is saying, okay, we're looking at this whole pie, and instead of pretending like we're going to shrink it down and freeze it in time, because we know that you really have to look at the last 3 years to determine the true value, it doesn't make sense to freeze it in time. The net result is that it will mandate that parties, when you have one spouse who earns the PERS and one spouse that does not, that the person who did not earn the PERS will get less of the overall benefit. It will directly impact that person in a negative way. I did want to make note that I do have a guest here today who is willing to testify when we're done as counsel talking about this, but it will mandate that attorneys looking at this will have to say whether or not we're going to expand alimony to make up for this in some other way. We might have to look at other assets to make up for this. Under NRS 125.150, that says we need to have an equal distribution. The ramifications are protracted litigation, increased costs of divorce, hiring experts and forcing this non-PERS member to take an asset that will never grow. It's like saying you're going to take a retirement share, but if it goes to you, your portion of that is locked in at a pretense, we're using a pretend lower rate to lock it in and never let that asset grow. And so it flip-flops everything and makes it so that if you're married and divorced in the earlier years, we will pretend like it's a shrunken down asset. It actually works the other way. If you are married during those high 3 years, that spouse could be married for the same exact 10-year period and get way more than someone else who's married for the same amount of time, overlapping the time that you earn PERS, and then that person gets more. So what is being sought after is something that's fair. And I think that word gets thrown out there with good intentions, but what's going on here is there's unintended consequences. So we're swapping out one injustice for another injustice, that the non-PERS earning spouse is actually harmed. I can answer other questions on this issue, but I would like to just pass it to my colleague, Mr. Springate, for additional input.
Good afternoon. My name is John Springate. I'm a certified family law specialist here in the state. I've been practicing about 40 years this year. Let's start with the time rule that we have now is settled law, and it's been the law that we've been dealing with since 1989. So for the vast majority of time that I've been practicing, this is the way that we calculate PERS divorces. This would be a radical change and an extremely unfair change. Consider the basic of it is with our firefighter, married for 10 years, and then working for another 10 or 20 years. If they were divorced and the firefighter retires at the 10-year mark, the community share of that portion of that pension is 100%. There were 10 marital years in 10 total years. And the spouse on retirement would be entitled to half. But members continue to work. They build on those earlier years. They get better jobs. And in this case, he works until, in this case, 20 or 30 years. The community share, that 10 years is now 10 out of 20, or only a 50% share, or 10 out of 30, only a 30% share. And that retired spouse, or the non-PERS spouse, is only entitled to half of that, going down now to 25% or even 15%, one half of that 30%. They don't know what that is worth. And we say that that spouse is taking a smaller share, however, of a bigger pie. And that's their benefit for having to wait those 20 years to find out what the total amount is and what's it going to be. Because at the time of the divorce, we don't know. It's virtually impossible without tremendous expense and guesswork to figure out what a person is going to be making. You're getting divorced at year 10. What are you going to be making as an officer or as a firefighter or any other PERS job in another 10 or 15 years? What will be your wage rate at that time? What will be your 3 highest and best? You might die. Your spouse might die. What are interest rates? And then carry all those payments out for that person's lifetime, because that's the PERS benefit, and then bring that back to present value now. That's a pretty complicated financial calculation with a tremendous amount of guesswork. And instead we say, utilizing the time rule that the Supreme Court has approved that we've had for 35 years, we're going to wait and see until the party retires. Then we'll know what their rate is, and we'll know exactly what the community portion is, bearing in mind that that community portion every year has been getting smaller as the member keeps working. That's their benefit. They're not only building on those marital years, but they're also reducing the portion that is being paid to their ex-spouse. The senator did make a point about people not knowing the effect, and I believe it was 4 years ago, the legislature changed NRS 125-150 to mandate that the courts set forth that if you have pension rights, you need to take care of that with a quadro, and that is required now in Section 2, I believe, of NRS 125-150 to be put on the bottom of every divorce to tell people that they have these rights and they need to take care of them. So bearing in mind that this is the essential fairness and how it basically works is not unfair at all. It is settled law, and there's really no good reason to turn it over. In addition, this bill has 2 other significant problems that you really need to look at. It carves out an exception for homemakers. For some reason, if you're a homemaker whatever that is, because it's not defined in the bill, presumably a spouse with no outside income or limited outside income, that spouse gets the benefit of the time rule. So now we have one entire class of spouses who go under the old rule, as opposed to new spouses who would go under this defined benefit rule. And if your spouse, the non-PERS participant, has their own retirement plan, that would be divided according to the time rule, whereas their PERS spouse would have their benefit defined by this frozen benefit rule. So you're getting, frankly, shafted if you're the non-PERS spouse. You're losing a greater portion of your benefit versus being the spouse of the PERS benefit. The way that we define it now, the way that we do divide it now, is the same for 44 states and the vast majority of private pensions. That's a consensus that it's fair and that it works, and it reduces time and cost and expense. Because as a divorce lawyer, I don't have to value that pension. And for the vast majority of people in PERS, they don't have the assets to find other assets to buy out of that. That is probably the single largest asset that most people have when you consider the length of time that it will pay and the amount of money that it will pay. And it's impossible for people to find enough other assets to buy the spouse out of that pension, especially when there's a significant amount of time in it. People don't understand how valuable it is for both parties, as it should be. So we would urge you to not pass this bill. We certainly have time for any questions if you have any.
Thank you. I think a couple of my members have questions. We'll start with Senator Wynn.
I know, I see that button there, it's hidden. In your, almost 40 years of practice in this area, have you had the ability, or is there any distinctions that can be made between what Senator Neal had talked about, how it appears that they're doing this in the military with the frozen benefit rule, and if it's being done in the military, why wouldn't it be something that we would utilize here in our state?
For the record, John Springate. I will note that we have one of our noted practitioners in Vegas here to testify as well, Mr. Willick, who can probably speak on that. But from my experience, there's a huge distinction. The military is not governed by community property law. In Nevada, we are, and we are mandated to make an equal distribution of the community assets. So if you impose this, every practitioner, every good practitioner, would be forced to start calculating these portions out and do, just as we've been doing in military pensions since 2017, figuring out the real cost and expense of what that change mandates and taking it out of other assets, taking more, in effect, from the people with the pension to compensate for the losses to the marital community and to the other spouse. But the single biggest change is we've got community property law, and the federal system doesn't have to care about that. Plus, they are downgrading and trying to get away from pensions anyway. They're going more to a 401k-based system, which is probably better for them.
And if we do have our guests in Las Vegas who want to answer these questions, you can go ahead and come to the table now. But I'm not, if you are open to answering questions, thank you.
Want me to answer that question?
Sure, go ahead, please. And please give your name and spelling before you begin.
Sure. My name is Marshall Willick, M-A-R-S-H-A-L-W-I-L-L-I-C-K. I am a certified specialist. I've been a Nevada divorce lawyer for more than 40 years, and I'm a national pension expert. I draft more quadros than anybody else in the state of Nevada, including all quadros for all the legal aid organizations in Nevada. And I do them for private employers under ERISA, for the civil service, for the military, for PERS, and for everybody else. And I think I can answer the several questions that were asked. Senator Wynn first. In terms of the military, this is only a sub-piece of the military cases. It only applies to active duty cases. All retired military personnel are still divided their pensions under the time rule. Senator Ellison asked a question about some case citations. I think those would be best answered by the letter that is sitting in front of him from an attorney by the name of Richard Crane, which gives you the critical case lines. And for Chair Scheibel, you are correct that no sums are payable until actual retirement, and it is always negotiable. So I hope that answered the questions that were asked, but if there was a separate question that somebody wanted an answer to, I'll be happy to answer it. Otherwise, I do have my own remarks, but I didn't want to interrupt Mr. Springate.
Thank you. I appreciate that. Let's finish up the questions, and then we'll go on to additional remarks. I think, Senator Nguyen, did you have a follow-up? Please go ahead.
In these, and I don't know if you know this because you practice here, but you had mentioned that 44 states have a similar system to what Nevada has now. Obviously, it sounds like there's potentially 6 states out there that have this frozen benefit type rule that's in play. Are you familiar with how that works in those states? I recognize that it's difficult when you have to guesstimate what the value might be in 20, 30, 40 years when someone retires and how they're going to do. What kind of experts do you have to utilize in order to determine those amounts?
John Springate, for the record. Thank you, Senator. Understand, however, the beauty of our system as it exists now is that we don't have to guess. As of the date of divorce, we know the amount of marital time. And the only thing that is unknown and that is put in a quadro and sent to PERS and simply left there is what is the eventual total time that the member has when they retire and what are their top 3 best years, so that there is no guesswork. The recipient spouse, the non-PERS spouse, knows that they have a pension benefit that is guaranteed and is set by PERS and will be calculated on retirement. The retiring spouse knows that he or she is going to have to pay something at that time, which will be a proportion. That's not hard. 5 years out of my 30, 10 years out of my 30, the other spouse will get half of that based on my 3 best. When we do it that way, we take that entire PERS issue off the table because we don't have to calculate it. Technically, though, we'd be doing that with forensic accountants or forensic actuaries. But bear in mind, we're talking about how old will this person be when they retire? How much money will they be making when they retire? How long are they going to live, or how long is the recipient spouse going to live? What's the percentage, right? So you can see where there are numerous unknowns in that calculation going all the way down, and then bring all that number back to what's the value to the spouse right now. It's an extraordinarily difficult calculation. Oh, and what are interest rates going to be? We know we've seen some fluctuation on that over the last several years. That's why that makes it such a difficult thing to actually value that pension, when instead you can take it, as we do now, take it completely off the table and say, you have 10 marital years, and when that person retires, all the numbers will flow, and you're going to get whatever you're going to get at that time.
All right. Further questions from Vice Chair Flores?
Thank you both for that, and I appreciate the amount of expertise you bring to the table. I know some of the questions that I've gotten, and I think alluding a little bit to the original hypothetical that was referenced, where person 1 is married to person A, divorces, and then marries person B. The final 3 years versus person A, who you were married to for the first 5 years. I think one of the things that maybe would help add some clarity, and you've hit some of it already, is I think when we think of a traditional divorce, we always treat assets where they stand at that point typically, right? So if you're married to person A and the house was worth $200,000, we know in 20 years that house will probably be worth a lot more. Now you're married to person B and that house is worth $400,000. I think we've made it a rule now that people are comfortable. Person B is going to get a lot more money out of that property than person A, right? Same thing if you have an antique vehicle. We know that the antique vehicle was worth 3 years ago amount A, now it's amount B, now it just keeps going up in value. So we traditionally treat everything and we freeze it right where it stands at the time of divorce. And I think because we're so accustomed to that, When we start talking about pensions, we want to treat it the same, and it creates that sense of confusion. So maybe you could help clarify that. And then my second question, so that I don't interrupt you. A person, let's say person one is married to person A at 2 years. So PERS have not vested. They divorce then, and then person one marries person two. They stay married for 5 years. Now PERS have vested, and they were married for a lifespan of 5 years. And then person one divorces at person B and now marries person C for the final 3 years. Should we treat those three individuals similarly? And if yes, if you could help us understand a little bit of why.
Madam Chair, members of the committee, Melissa Exline for the record. Let me address, and I really like this example. I think this highlights the difference on your house example, okay? So we're locking it in, we're valuing it a house at the time of divorce, or some other asset. The PERS pension is unique because unlike any other asset, it would be like saying that the house has this value, but if it goes to party A, it's going to balloon in value at the last 3 years only when you're holding it, okay? But if you take it, we will lock it in and we'll pretend like the home will never appreciate. So what you're doing is inherently changing the value of an asset and saying if one person takes it, it will be devalued. And if another person takes it and they hold on to it and they keep in that home for a long time, then at the last 3 years of holding it before they sell it, it's going to be increased in value, but only in my hands and not in yours. I'm the PERS member and you are not. So it's a fundamentally different type of asset to value in that way because every single year builds upon the other, and then we have this high 3 overlay at the top. The high 3 is important. And that kind of feeds into your next example where you're saying, okay, what if we have a 2-year marriage, then a break, and then that person remarries again, then there's 5 years, and they're still working their PERS job, and then maybe they divorce, and now they're married during their high 3 years, and they're divorcing again. Well, let's pretend that they were working their PERS job 30 full years, okay? And so what would normally happen is you would look at each community as a percentage of the total, and you would determine what that is, and the high 3 is the part that kind of lets us figure out what that will be at the end of the day. And I know I'm oversimplifying this to some extent, but nonetheless, what you're doing is instead of saying it's most valuable at the end, we're saying we're looking at the total. And so what is happening here, if you're looking at SB 126, is you're really devaluing the early years, and in a way that kind of doesn't make sense because we know that it's going to balloon at the end, like in my house example. And then with the 3 years at the end, if you're married for only those 3 years, you may be getting more than the person who was married to you for 5 years, right? Because that was in the middle. And so recognizing, and this is what they went through in the case law, so this is what the Supreme Court was grappling with in trying to come up with a fair system that looks at an asset that changes in this way at the end. They said, look, every year builds upon the other. We have to do it this way because it's the only thing that makes sense. And what I want to point out too is that the creating this homemaker exception, it seems like it's giving a benefit here to a homemaker, but it's not. It's a falsity. You don't know really what a homemaker is. It's pulling this term out of alimony law and it's dropping it in the middle of this PERS pension without any explanation of what it really means. I think that's going to lead to more litigation. When you have an asset like a house that's where we're not going to be able to truly value it on the day of divorce, because if it goes to one party, it's worth more, and if it goes to the other, it's worth significantly less. If I'm the person who is going to get an asset that is worth significantly less to me, then I am invested in trying to figure out how I'm going to be okay making ends meet when I'm in retirement in some other way. I have to litigate. I might have to ask for alimony. I'm going to be forced, only in PERS cases, to increase the costs of litigation, and it mandates that we're going to have to potentially get experts, really do a deep dive in how we make sure that that kind of a client is okay. Because you're really putting the two parties in a very unfair position as to each other. If somebody sacrificed more of their career to stay home with the family, didn't work as much, that person, whether they're a true homemaker or not, maybe did more and had sacrificed their career to some extent. I am concerned for those parties also in this case being stuck in litigation the way that this statute is written. So I hope that helped make that a little bit more clear.
Madam Chair, if I could have a follow-up, and thank you for that. I appreciate the breakdown. I am curious, and I forget your name, sir. I apologize.
Sorry, Springgate.
Thank you. You had discussed that already in the NRS, there is a requirement for notice. Are you in opposition to that portion of her bill now? I'm curious to know if that was on its own in the bill, would you be, and more or less, my mind is going into pro se litigants. We're in a scenario where even when we say things, we know that so often individuals just have verbiage read at them, and it really does just feel like verbiage. And I think Senator Neal was aiming at the idea of having more of a breakdown. And I think of other scenarios where we do things like this, even with the Miranda rights. With kids, we even treat them differently, right? We now have a different Miranda right reading because we understand that sometimes it just sounds like straight up verbiage, and we just say yes, and we check the box and sign here, and then 20 years down the road, we're stuck having this combo. I was curious to know if we were just talking about that on its own, how you felt about that conversation.
We aren't, thank you, Senator. For the record, John Springgate. We're not talking about that at all. That is already in the law. I believe it was 2 legislatures ago. It was mandated that the court now advise people of that. That is not any portion of this bill, and nor is it sought to be changed, nor should it be changed. People need to be advised that, and what it really says is if you have pension rights, you may have to take steps to make sure that you collect those, which is absolutely correct. Recognizing that probably better than 80% of our litigants in Washoe County are pro se or self-represented, I don't know how to make this area of law a lot simpler because, as you're aware, it's complex and it causes problems for lawyers. I think probably telling people that they have those rights and they need to seek the benefits is maybe the best you can do at this point. But that's not part of this bill. It is the law and it should be the law.
And the only reason I'm saying that is Senator Neal, in the onset of the conversation, was addressing just how complex this is and how there's this surprise that's happening at the end. And I'm thinking, my mind is just going in a collaborative kind of train track, saying, is there a way of maybe addressing that portion of it, even if we can't find consensus on whether or not we should change the formula or not? And that's the reason I posed it out there. More of a, is there an opportunity to work together on some of this? Thank you.
Melissa Exline, for the record, and just to address your question, last session with the bill, I think that was the portion of the bill that we did not oppose. Like, explain it. Absolutely. And so I think that was last session as part of Senator Neal's prior bill. And it says that it already says that you shall provide an explanation and ensure. And I think that language was added last year. This edition is saying a full explanation. I have a little bit of concerns of what that means. It's putting the onus on the court, actually, to say that this has to be in a decree. They're already doing it from last session. They started adding some language to try to explain this on pensions and retirement. I don't personally have any problem with trying to explain something to folks so that they can try to grasp that this is a big deal. But I think it's already happening, and so I don't know that the use of the word full explanation is adding more to it, albeit I don't have any personal concerns with that particular issue, and I think that she's coming from the right place on that. Although I do think it's not necessary at this point. I would add that.
All right. Any other questions from members of the committee? I'm not seeing any further questions. I thank you so much for your willingness to answer questions in this hearing. And with that, we will continue with opposition testimony. We'll start with folks here in Carson City in person, and then we'll go down to Las Vegas in person. So whenever you're ready here in Carson City, just hit that microphone button and give us your name and its spelling before you begin.
Thank you, Chair Scheibel and members of the committee. My name is Bridget James, BridgetJames, to testify in opposition to SB 126. The reasons I oppose this bill is because it will harm people like me. I was married for 23 and a half years, to a member of law enforcement. I did not think we would ever be divorced. However, when we were in this position, the importance of PERS and the pension became very clear. Other than our house, it was one of the largest assets. It is wrong to put someone like me that did a lot of work for my family and children in the position of getting less of our community property pension. Thank you.
All right. I'm not seeing anybody else coming down to the table in Carson City, so we'll go to Las Vegas. Please go ahead.
Thank you, Chair Scheibel, members of the committee. Again, Marshall Willick, for the record. I am a Las Vegas family law specialist. For the reasons stated by Mr. Springate and Ms. Exline, a frozen benefit would violate the Nevada community property laws. It just does. The reason for it and the explanation for it is mathematical. It was set out in the cases. There's actually 4 primary: Gemma, Fondy, Sertic, and Wolf. And the Supreme Court did a pretty good job of comparing the various alternatives, including a frozen benefit concept, and why that would be inherently inequitable to any spouse. To answer Senator Flores's questions, yes, there is a notice that the courts are handing out. They are very concerned about not being put in the position of giving legal advice. I think adding a couple of extra words saying full will simply invite litigation against the judiciary, which is probably a very bad idea. At the request of the judiciary, I actually drafted the notice, which a lot of the judges statewide are giving out to litigants to explain how this stuff works. But it is impossible in a divorce decree, and it is impossible in a single notice to explain all the nuances, because it is complicated. But it isn't complicated because the lawyers have made it that way. This is something that was created by others at a different time. Congress mandated quadros for all private retirements in 1984. It's been that way for 40 years. The civil service has its own rules mandating specialized orders, as does the military, as does PERS. But there are 4 different retirement systems, all of which have the same requirement of how to divide things. This bill would only affect PERS participants, meaning there would be a terrible inequity and equal protection violation. It would treat the parties terribly unequally if both parties have some form of retirement benefits. And in modern society, that's true most of the time. It would give the PERS participant a much bigger share of the other spouse's property than that spouse would have of the PERS participant's property. And that is inherently unfair and unequal. Successive spouses, which was raised by Senator Flores, would also be treated very unequally. The math is set out in my detailed explanation, but the short version is that with a member getting exactly the same benefits, 2 spouses married for 10 years to the same individual, one of them would get about half what the other one would get for the same length of marriage applied to the same retirement. And for the reasons set out by the Nevada Supreme Court in the cases, that is simply not fair to the earlier spouses, because those earlier years, as Ms. Exline said, are the building blocks to the final receipt of the amount. To obey the mandate of 125-150 to equally divide marital property, any frozen benefit will require a court to give additional compensatory payments to the other spouse. In other words, the only thing that will be accomplished is that it won't come out of this bucket, it'll come out of that bucket if the lawyers do it right. The only people that are going to be hurt by this are poor people, because the reality is they're not going to be able to afford me or somebody like me to do that compensatory order, which means they will simply get shafted, in Mr. Springate's words. And that is something which should be avoided at all times. The other speakers are also correct that it confuses alimony and property concepts. And the Nevada Supreme Court has been quite clear that those benefits are for different purposes and they fulfill different functions. One is not to be used as a substitute for the other. And community property is to be equally divided in the absence of written findings of a compelling reason stated on the record to divide property unequally. This bill, regardless of its motivations, divides things unequally. And to do that to a single class of people creates haves and have-nots without any good reason. There is essentially no good that could come out of this bill. It will increase costs, it will increase impoverishment, it will cause disproportionate impacts on equally situated people, and it will raise costs for everybody. There's no good that can come out of it. When the frozen benefit rule was suggested for the military for active duty people, the ABA and the AAML both jumped in and attempted to do something about it. But it was raised by a junior member of Congress for a voice vote on a must-pass defense authorization bill, and it passed without any hearings or any opportunity for any input. And the organizations that I'm speaking of which I'm a member of the legislative committees for both, have been unable to fix it since then. They want to, because they realize that it's horribly inequitable and it leads to all kinds of extra work just to achieve equity. In every military case involving a active duty military pension, my office, who does the orders and drafted the model order, tells the attorneys that do it that they have to come up with an additional compensatory payment to the spouse to make up for the federal limitation of the frozen benefit on the active duty pension. It complicates things enormously, doubles the cost of the creation of those orders. And if it's done right, get you exactly back to where the time rule is. If it's done wrong, then the spouse is simply shorted. I'll happily answer any other questions, and I'd like to pass to my associate here, who has her own remarks. But if there's any questions on this, it can be very technical, but the technicalities were not something that the lawyers here came up with. Congress enacted some of it. The state of Nevada enacted some of it in coming up with the PERS statute, which was based on ERISA. And each retirement system has created these requirements for proper distribution. It is incredibly unfair to treat one group differently than everybody else. Thank you.
Please go ahead.
Scheibel, members of the Senate Judicial Committee. My name is Shelley Cooley. I've been a licensed Nevada family law attorney for more than 20 years. I'm a certified family law specialist, and my practice is devoted exclusively to family law. I oppose Section 2 of SB 126, that is not just inequitable. My esteemed colleagues, Melissa Exline, John Springate, Marshall Willick have addressed issues, and I'd just like to point out a few of the practicalities of adopting the frozen benefit rule. First, we need to look at the folks who are supporting the bill. They are PERS members. The folks who are opposing this bill are Nevada family law attorneys who represent both PERS members or their soon-to-be exes. And we are overwhelmingly opposing the frozen benefit rule because it is unfair for our clients or our clients' spouses. In Nevada, we have to divide assets and debts equitably, and the frozen benefit rule is not equitable for the non-member spouse. The folks who support this bill speak volumes as to the unfairness of this bill, and it does not have the citizens of Nevada as a whole. It is only looking out for the benefit of PERS members. If you believe that two people who are married and create assets together should divide their assets equally at divorce, then you should oppose and vote no on SB 126. It's also very important to remember that the language in SB 126 says that the court shall base its determination. What this means is that the parties cannot agree. It doesn't allow for that language, but the court shall means that there has to be a trial. Trials are expensive. Trials take time. Trials result in protracted litigation. So what is going to happen is that every divorcing member of PERS will require a trial so the court can determine the value of the pension or the retirement benefit interest, even if all other issues are resolved. There will be dueling experts that will need to be retained to assist the court in determining the value of the interest in the pension, which will further increase costs. And if a trial goes forward on the value of a pension interest, any reasonable family law attorney will be sure to include an alimony claim, which will further increase costs. And even on a short-term marriage, you could have an alimony claim that is longer than the length of the marriage. This will result in many unhappy PERS members if we adopt the frozen benefit. And like I said, there are no exceptions for parties' agreements based on the plain language of SB 126. SB 126, as Marshall said, violates the Equal Protection Clause because it treats parties differently. What we have to remember is that we have a carve out for PERS members only. But what about members of private pension benefits? You could have folks who have a PERS member and a private pension. If we adopt this, then the non-PERS member is going to get a lesser share of the PERS benefit than the PERS member is going to get of the non-PERS member. It's not fair. The time rule, as our Supreme Court has said, is fair and is equitable, and it is the only way to equitably divide community assets. I urge you to vote no on this bill and to disappoint a select group of Nevadans rather than disappoint and enact something that is unfair to all of Nevada as a whole. Thank you for the opportunity to testify. I would be happy to answer any questions.
All right, thank you so much. I don't think we have any more questions, and it doesn't look like there's anybody else in Las Vegas to testify in opposition. If there is, if you could just make some kind of signal. Okay, I see shaking heads. So that concludes the in-person opposition testimony. We'll go to the phones now for opposition testimony. In order to get out of here in a timely fashion, we are going to limit the phone testimony to 2 minutes per person. And I'd like to let you know that you're also, again, welcome to submit comments in writing. And you can also say, I agree, ditto, echo what other speakers have said, since we have had such thorough explanations and testimony on this bill. With that, let's go to the phones, please, for testimony in opposition to SB 126.
Thank you, Chair. The public lines are open and working. However, there are no callers to provide opposition testimony at this time.
Okay. In that case, we will move on to testimony in the neutral position. Anybody wishing to give neutral testimony in Carson City or Las Vegas is invited to the witness table now, and I don't see anybody, so instead we will go to the phones for testimony in the neutral position.
The public lines are open and working. However, there are no callers to provide neutral testimony at this time.
All right, then that concludes testimony on SB 126. Would the sponsor like to make any closing remarks? All right, but then we will conclude our hearing on SB 126. The hearing is now closed, and we will move on to the last item on our agenda for today, which is public comment. If there's anybody here to give public comment, now is the time to come down to the witness table in Las Vegas or Carson City. I don't see anybody coming in person, so we'll go back to the phones quickly for public comment. Is there anybody on the phone?
The public lines are open and working. However, there are no callers to provide public comment at this time.
All right, then that concludes public comment and our meeting for today. We will be back tomorrow at 1 p.m. Until that time, we are adjourned.